Testing, testing, testing. Good afternoon, everyone.
Hi, good
Hey,
afternoon.
good afternoon,
Good
Ryan.
afternoon. Good afternoon, Donna.
Hi, Donna.
Hi.
You guys got your lunches.
Yeah, thank you.
Yes, we did. Thank you.
I'm not sure if the CJ is he off island but it sounds like he didn't order lunch, but he's planning on being in.
I don't know where he is. He may be off island. I'm not so sure.
Oh,
That's Annie.
But he said he'll be here.
Yes.
We can hang on, right?
oh, definitely.
Yes, thank you. We have others joining like Annie. So we'll keep you posted.
Okay.
I wonder if Carol's coming in person or if she I didn't bring my phone.
This is our CLC.
Oh.
Hi, everybody.
Hello.
Hi.
Today. Good afternoon, everyone.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor.
We do have a quorum now, so we're missing Jackie, but we get 3 of the 5 members, so we will go ahead and start the Public Defender Service Corporation Board of Trustees meeting for June 25th is called to order. Will the secretary please call roll?
Yes, Your Honor. Chief Justice Robert J. Torres,
I'm present.
Presiding Judge Alberto C. Lamarana III,
Present.
Trustee Donna Muñoz Canata,
I'm present.
Dr. Christiana Whitman,
She's excused. She wrote us and said she was going to be unable to make it today.
and Guam Bar President Attorney Jackie T. Terlahi.
She's not here now, and hopefully she'll be able to join us, but we do have a quorum. 3 of the 5 members were present, and notice of the meeting was appropriately published, 5 working days, and also the 48-hour notice as required by law, so we can proceed with the meeting, unlike the May 28th meeting, which did not occur. The first item is the approval of the minutes from the April 23rd meeting, and there also, I guess, on there, the approval of minutes from the May 28th meeting, although that meeting did not constitute a valid meeting. So can I entertain a motion to approve the minutes for those?
Move to approve the minutes.
Motion and second it.
He beat Trustee Kanata to the punch, so to speak. So I assume you'll second that, Donna?
Yes. Yes,
All
sir.
right, so it's been moved by PJ and seconded by Trustee Kanata. All those in favor say aye.
Aye.
There being no objection, those minutes for both of those are approved. The next item on the agenda are the under old business is the financial status update and the allotment releases. So Mike, are you going to give that report?
Yes, sir.
All right, you can proceed.
Thank you. Good afternoon, Board of Trustees. PDSC received a sum of $1,211,204 after the last board meeting, which brings both PDSC and APD at 98%. The next on the report is the ICJR. As of May 31st, 2024, expenses were $125.13 for personnel and $22,445 for travel, supplies, and equipment. The balances were at $37.89 for personnel cost and $1,448 for operations. This funding will be used until such time as Stock 22 is appropriated to us by the Governor's Office. Next is the Elder Justice Center. Invoices for February through May 2024 for a total of $64,011 were submitted to DPHSS, but we have not received the payments as of today. For JAG, which is the Access to Counsel, a quarterly report will be issued next month in July, in which it will be indicated that the entire grant of $26,658 has been expended. And with PDSC has contracted with Westcare Pacific Items Inc. in February of this year to provide legal services to veterans. PDSC has submitted invoices as of May 2024 totaling $1,399, of which $870 have been received. And these were the invoices issued for March and April. And that's all for the financials.
Does anyone have any questions for Mike? Mike, I did the Access to Justice grant. Was that the grant for the to prepare the Access to Justice from the 6th Amendment report, or is that something different?
No, that's separate, I believe. That's the JAG report from the Edward Byrne Memorial.
Okay, all right. So it wasn't for the access to justice grant for this Sixth Amendment right to counsel. Okay. Any questions for Mike? All right, there being, and Trustee Terlahi is present now. Let the record reflect that she has joined us. All right, then the next item on the agenda is the report from the PDS Executive Director.
Thank you, Chief Justice. But since you brought up that Burns JAG Access to Counsel grant, we actually got it extended. It ends in June. And what it did is we set up Zoom meeting rooms in each of the detention facilities, but that thing will expire in June. So it was good while it lasted. After that, we're gonna have to figure out what, we have about 6 or 7 computers out there with internet capability. So we're gonna have to figure out what to do with those when they get pulled from the detention
Was
facility.
that expiring this month, like in the end of this week?
Yeah,
Yes,
is that?
Yes, that's correct, Your Honor.
it expires.
And we don't have a plan yet for those, what we're going to do with either the equipment or the recurring charges that are being incurred?
Well, the recurring charges are just gonna end the data, and the computers, we have to figure out with BSP whether we keep it or do we return it to BSP. They haven't really said, right, Kath?
That's correct.
May I ask a question?
Sure.
Steve, were they helpful? I mean, was the process, was it much needed?
Well,
What was
it should have been a lot more productive than it was, but DOC's short-handed, so they've had difficulty setting it up. But we did spend a lot of time with them trying to work out schedules and everything. But at this, we're trying to make it easier for DOC. We think it requires less work on their part for us to meet our clients through Zoom. And I think, I don't know, maybe Jackie used it once, but it's not working the way it could. And so the grant's ending, and I don't know if it's worth using local funds to continue. So our attorneys will just be going there in person.
Steve, what was not working? Was it because they just didn't want to utilize it, or was it because the internet wasn't working properly, or what was it that wasn't working?
Yeah. So the internet was working well. It turns out it was being used more for court hearings than for client meetings. We have one in Post 6, which Post 6 is admin seg. And to actually get there, you need 2 of their SORT team members to accompany you. So we haven't even been able to visit our clients there with that. But we have, our Zoom account tracks usage, and it shows it's being used for court hearings. But as long as it benefits our clients, it's okay. It's just that, DOC maybe should pick up the cost of it if they want to use it for their purposes. But yeah, we met extensively with Major Ugin, and it's just, I think because they're shorthanded, they can't really accommodate setting up these visitation meetings.
What are the rules after the grant is over with what to do with the equipment?
That's what we're.
Is it ours now?
Ms. Donna, so we're going to be coordinating and communicating with BSP to determine the future of the equipment.
Okay.
Yeah, it does seem on its face, obviously that allowing your PDSC to meet with their clients via Zoom would not only result in savings or efficiencies for PDSC, but also for DOC. And, just hearing now that the program hasn't quite gotten off the ground in the manner that has been expected, and you know, hasn't been implemented completely, or been utilized in the way that it's been was expected to be, you know, is somewhat unfortunate. And I think that you know, a reexamination of the process and what caused it not to you know, come to its full realization, and consultation with DOC, I think, you know, we probably should get a handle on, and get I'd like to see a written report, if we could, from DOC, or about why they feel that this would not result in savings for them, or time constraints. It seems sending attorneys up there, the time to bring them in, be with them during the time that their clients are going to be meeting, particularly if there's multiple people, would take, you know, more man hours than it would to have a secure area within purview of the DOC guards currently. But you know, I probably don't have all of the details on it, but I just think that you know, it just doesn't add up in my mind, why the program shouldn't result in efficiencies for both DOC and PDSC.
Yeah, we totally agree. But yeah, I mean, we're still working with the major about that.
Yeah, I'd ask them if we can, and you can even, you know, tell them that the Board of Trustees and the Chief Justice is asking if you could, you know, just do a short memo. It doesn't have to be comprehensive, explaining why he, you know, believed that you know, they weren't able to if that's the reason, you know, realize all of the capabilities that were there from the systems while they're intact. And
Yeah,
so what, just remind me, so it was the computers, and then are we paying for the internet connection?
with the Burns Jack grant covers
Right.
the internet through end of June.
Yes.
All
And
right.
then we
So
did let
have we
Danielle know.
notified our provider that come June 30th, we're not going to pay anymore? Or terminated the service?
No, I think we're in the process of that. We're still trying to reach out to Burns Jack grant program, see what they want to do with everything. And then we did let Danielle know that it's going to end pretty soon, so they might need to make arrangements for other Zoom rooms, because we've, as often as we show up at magistrate hearings, we see our cameras being used for magistrate hearings. So I hope they have other things set up too, in lieu of our equipment, once we have to close the program.
Well, I want to make sure that there's no interruption. If the equipment that's being used is also involved with magistrates and not only attorney-client communications. So I'll also, and you say you're in touch with Danielle about that?
Oh, yes, probably like 2 months ago, kind of mentioned that this program ends in June, and we know that the court's been using it, so.
And have they said anything to you about replacing that, or?
No, so maybe that's something we could work out with the.
I mean, Steve, we're here now with 3 days to go before, 4 days to go before the end of the week and end of the month. And it seems like, you know, we don't really have a good solid game plan, even in terms of notifying our provider about termination of the service come June 30th. If that's what's the case. And it seems like all the money's been expended. So there doesn't appear to be funds available, even though you say, you know, you're trying to contact them about what to do with the equipment that was purchased.
Yeah, that's correct. All
right. Well, I mean, I'll on the court side, obviously we don't want interruption of magistrate hearings. So I'll have to, you know, deal with our administrator and address those issues if indeed we're relying on those to accomplish what we need to do. So, all right. Is there anything else, Steve? I guess on your report, getting back to the caseload.
So we did, yeah, finally, we provided our stats. We've been putting it off for the last couple of board meetings because of our budget. And so we set it up. One is our cumulative report. That's on page 14. That shows basically we have about 1,063 prejudgment cases, and then another 826 that are prejudgment with outstanding bench warrants. And so some of those might be really old and some of those might be relatively fresh warrants. It's kind of hard to differentiate between the two. So we're looking at about 1,800 prejudgment cases. And then, of course, all the ones we take care of in probation. So altogether, we have about 5,597 pre and post cases that are still open. And so, and that's on page 14. Page 15 is just the second quarter stats from January through March. And we're gonna do our third quarter stats at the next board meeting. And so we opened, looks like 280 cases in the second quarter. That small table in the bottom shows that 270 cases were closed, but a lot of those are due to, like, if someone completes probation or the family violence program, then the cases are dismissed and expunged, so those are counted as closed. Appears we had a higher number of conflicts. Part of that is because you know, when Jamie Spivey passed away, we had a lot of the cases reassigned to us, and then we had to review them once again to see if the conflicts still exist. And so that's kind of why it's a little elevated there. And then we did, there were 6%, I mean, 6 cases we had to turn away due to income exceeded, despite the fact that we did increase the guideline amount. And then 4 retained, substituted out retained private counsel. So those are our second quarter stats, and that's just January through March. And we'll get the third quarter stats at the next board meeting.
Any questions? for
I do,
Steve?
Mr. Chairman.
Okay,
Steve, where's your electronic monitoring statistics?
So
I mean, how many
we-
of your clients are in electronic monitoring? How many have applied? And how many were rejected? No?
Okay. We can get that to you. I know that it's standard procedure now to do an electronic monitoring packet for pretty much everyone that's confined. So, and if the only times we can is if they're homeless and they don't have a place with power or a telephone. But we'll get those numbers. I know that our investigation division tracks how many applications they submit, and then we could figure out how many have been approved.
Yeah, can you put that in your report next time? How many have you applied? How many are rejected? How many were approved? And secondly, how many are post-conviction and how many pre-trial? Because I know some of the judges, including myself, in post-judgment, put some of these defendants under electronic monitoring because of their continued violations, especially when they don't report in. So I like to see those statistics because I like to find out how well our program is going. And since you and APD handle 90% of the cases, or 95, I like to see those. Okay.
Oh, yes, Your Honor, and that's a great idea that they're using it as a sanction for probation violations. So
Yeah,
we'll see if we can get those stats.
Yeah, I do it a lot for Veterans Treatment Court, especially, huh?
Mm.
Instead of locking them up, huh? And it seems to work. So
Yeah, that extra supervision. Oh, no, I totally believe in the electronic monitoring system. Even the really active ones respond very well to that.
all right, is there anything else? If there's nothing else to report, Steve, then we'll hear from the APD managing attorney.
well, one more question, but
Sure.
you know, and this applies to APD. You know, I'm concerned because 90% of the time, the Attorney General is very quick on determining eligibility, especially for family violence deferred. And I like to, in many cases, the public defender, APD, don't respond very quickly. I like to know why. I've got cases where it's sitting for over 6 months, even though they were declared eligible earlier, like a month after the cases were filed. So I wonder if you can speed that up, the process.
We'll definitely discuss that at tomorrow's attorney meeting.
Because I've had eligible defendants, 8, 10, 1 year, nothing has happened, so I like to know what's the delay, huh?
Okay, we'll get that information.
Okay. Okay, thank you, Mr. Chairman.
All right, thank you, presiding judge. Annie, with the APD managing attorney's report.
Hi, thank you, Your Honor. Well, we put in just for May, the stats for May. We received 48 cases for the month of May. And to date, we have 236 cases. And then, so we have 528 pretrial cases. And then the rest of the below are the stats going all the way back to 2018 regarding various cases from public defender to APD, our withdrawals, and what we have to judgment and closure orders. We did, now that I know about the EMP, we'll put that on there. But could I ask Judge Lamarana, did you want are the stats that you were requesting for EMP is applications, denials, post and pre? Is that what you like?
And acceptance.
Okay. Applications, acceptance. What I'm also finding, and I don't know how to track this either, but those clients who get EMP and then violate for some reason, either they cut the monitor off or they violate the EMP. I mean, I don't even know if we can track those stats, but we do have.
You can put them as revoke or violations.
Oh, okay. Okay.
And that applies to you, Steve, okay? So if the defendant, violates the conditions of EM, I hope you consider that as either it's revoked or violated, or they violated the condition.
We have a lot of those anyway.
Yes, I know.
So anyway, so I guess for the next board meeting or in July, we can actually do the quarters. We'll be up to date on the first and second quarter for the overall stats.
I know that Ms. Dunphy has left the island or left the APD.
Oh, right. So she's leaving. Actually, she's already resigned, and we now have rehired Shinju Flynn. So she's back on board. She just started last week. So she's back. We'll put her name up there for the next board meeting.
Okay. Any questions for Annie? Any trustee or APD managing attorney about her report? If not, then we'll go to the Civil Law Center.
Thank you, Your Honor.
Good afternoon, everyone. Our stats are in the next 3 pages. We provided statistics for the Advocacy Center, which is the, and it might be page 19, or is this the first page? 20? Yeah. So page 19 is the Advocacy Center. Pages 20 is the Civil Law Center, which is basically like our guardianships, and then our Elder Justice is on that page as well. And page 22 is our veterans grant statistics that we provided. So that's a small grant that we received from WestCare. I think it's about $10,000 and it expires in October. So it was like a pilot project we're working with on WestCare to provide assistance to veterans that are at risk of homelessness. As you can see, our numbers remain either current or they've gone up for the attack, we're seeing a rise right now in intake on protective orders. And then elder justice, we've actually hit about, opened about 50 plus cases last month, and closed maybe about 60. I think we closed 60 or close to 60 cases. We did our first community outreach where we actually did a mobile clinic in the Inarajan Community Center. So we actually did the work on site and was able to assist 7 of the clients there, with 11 different services like power of attorneys and wills. So that's what we're working on, is trying to figure out a good system so we can do the community mobile clinics at the different various community centers, as well as even we're looking at possibly moving into the churches where we can reach out to the elders that attend mass, maybe provide it there, and then into the other communities like the FSM community. So those are things we're talking to the team about, but our stats remain consistent or have increased, and we're trying to we continue to monitor what's being requested. So those are the services we receive. So at this point, I'm telling them to take, anyone comes in, we just do an intake process with them and figure out what services they're asking for, as we'd like to eventually expand in those areas to assist the community.
Any questions?
Yeah, Carol, how many guardianships have you filed in court?
So we
I-
filed, if you go to civil law, we filed a total of about 34 guardianships. So what we're doing is where there's a CPS referral that's done and CPS doesn't substantiate those reports, but it's because like there's no guardianship or no proper custody arrangements, which is why we're hoping to get the local funding so we can expand in like uncontested custody, so we can get custody orders for fathers, or even establishment of paternity for fathers who are not on the birth certificates. So we've done 34 to date. That's from October to present. So CPS will refer the cases over to us if they're income qualified.
Yeah, because my concern is that many children are left without their parents because they're incarcerated or.
Mm-hmm. You can
Right.
send them over, Your Honor. Send them our way.
Yeah, because I like to know if you catch these people, because I'm concerned that many of these minors don't have a guardian to, provide financial help to them, or help.
Eventually we will, Your Honor, because those they're not able to like register them for school, or they're not able to get updated medical. So what happens is a CPS referral will be launched. So those are some of the cases we actually have where a parent is either deceased or the other one's incarcerated, or we have some of them where they just like they're like homeless because they're on drugs and they were left with the grandparents. So those are the cases that we've been helping with the guardianships. And what we can do is we can try to do some other outreach, like even in the schools, just to identify the services we are providing. But we've done a lot. I mean, that's the bulk of the referrals coming to our office on the guardianship, is actually those CPS kinds of cases.
So CPS refers clients to you, right?
Yes, they do. Yeah. So what happens is if there's they get a CPS referral from the school, like example is the child can't be registered or there's no updated annual physical. When they find out, it's because the biological father is either not on the birth certificate, or the child was left with grandparents because the parents no longer they're either incarcerated or they're on drugs and they're homeless. There's no guardianship in place. So those are the cases that are coming our way right now.
So DOE knows what to do, contact you.
I've been talking to them, so they know a little bit. I've talked to Nadine Cepeda, but I can do have some conversations with them so they're aware of it. And I think they know now because we've been appointed in some of the guardian ad litem cases for PINS cases. So of course, when I talk to the schools, they're like, oh, what are you doing now? So I explained to them where I'm at and what our office does. So we are looking at ways to of course promote, to of course tell the community about our services, because we know there's a lot of, even in the elder justice side, there's a lot that needs the service, but they're not aware that it's existing, or they don't know what to do. So That's the reason why we're trying to do mobile clinics. And we're actually trying to do mobile clinics as well on the guardianship side. So we're going to work with Total Guam at one point where they do their mobile medical stuff. We're going to work with them and go and do the outreach so that we can reach into that population that's not getting services.
Yeah, how about the senior citizens? Because I'm just really concerned about children that are left behind because the parents are not present.
Mm-hmm.
That's
If
something
you have
we'll-
those cases, Your Honor, please send them our way.
Oh yeah, don't worry about that. But or that some people that may need health care. And many of these parents, grandparents, or grandaunts or granduncles can put them in their insurance policies so that they can be covered.
Yes, that's the plan, Your Honor. So we do want to start doing mobile clinics, and the plan is to try to execute what we can while we're like right there on the spot. So we did a trial run just so we could figure out what we need as far as like the amount of laptops we're going to need and people and the time. So we were at the mayor's office for like 3.5 hours to service seven clients.
Okay, great. Thank you.
Thanks.
And so, Your Honor, I know that I've actually referred some to Carol, like where I had a client who was deported. He had 8 U.S. citizen-born children, but he had to go back to his home island, and the bio mother went back with him, leaving an adult daughter as the physical custodian. So Carol was able to help her get the guardianship. So really, I mean, they're really providing a great service.
Thank you very much. I just need maybe because to me those numbers are kind of low. I don't think we're really meeting the needs of a lot of our people in the community that are in need of these type of services.
I agree, Your Honor. That's why we're hoping that the legislature gives us that local funding, because right now we're operating fully under federal funds. So what's really letting us float is the ARPA money that Steve is so kind to give our division to use. Aside from that, we're limited in the services because of TAC, or it's funded under TAC, and it's funded. So TAC is for protective orders, and EJC is, for seniors. And so, the hope is that we get some local funding so we can expand the services and start doing more for the community.
Great, thank you.
All right. No, and we'll wait to see what the legislature does on that. You heard at the budget hearing, it didn't seem that there were a few that were necessarily excited about that aspect of it, wanting the focus to be on indigent defense, right? So, but I do think we do see value, obviously, in the programs that are done, because we recognize that there are people who need civil representation who can't afford it. The civil Gideon issue. All right. Any questions? Anything else? If not, let's go to the next item on the agenda, which is the amending the administrative assistant to the administrative officer. And I understand that we're going to remove this item from action.
Yeah, I mean, we don't really need action on it now because we had an AA who left to become an AO at a different at public health, and then decided to return. So we don't really have a vacant position, and really we weren't trying to amend a position with someone in it. We were trying to create this position, the administrative officer position, to use in the event that we eventually have an opening, and then we can convert that position. But so it's kind of moot at this point. So we could take it off the
All right,
agenda.
We'll take it off the agenda since there is not any vacant position that would require us to maybe adopt a new position and eliminate an old position, since the AA position's occupied, and that will be removed. Then the next item is the executive director compensation, classification, and performance evaluation. As you know, we had a discussion about the fact that the executive director, and is someone from PD gonna speak to this first before I say my comments, or no? All right, so I'll just go ahead. We had discussed this a couple of meetings ago, about the executive director's compensation in light of the adjustments in the attorney pay plan. The executive director did receive an adjustment when there was an original adjustment made to all of the employees, I believe. But because he was not on the attorney pay plan and was on the executive pay plan, there was not an adjustment made when all the attorneys went up. Statutorily, it appears that the executive director is supposed to be a classified employee on the attorney pay plan, but the last three, I believe, executive directors have all been unclassified and on the executive pay scale, not on the attorney pay scale. He has to be an attorney and in the classified service. I'm not sure they have to necessarily be on the attorney pay plan. And so we need to evaluate and determine what makes the most sense, whether to keep have flexibility in terms of the compensation that might be paid and have the executive director be a unclassified employee, whether the executive director who has to be an attorney should be on the attorney pay scale and in the classified service, or whether we should look at some other hybrid or an executive pay plan scenario that maybe correlates with the years of experience based on the attorney pay plan. And at the same time, the performance evaluation for the executive director has not been conducted since 2017. I guess there was no evaluation by the prior board, and there is a copy of the performance evaluation, the last performance evaluation that was in the packet, and you can go to that. You'll see. And it was an assisting, and this was really, I think, a basis for, it was more of an evaluation that formed the basis and provided input for the for the board, I presume, to look at the evaluation. And it looked at, and it would, just based on the numbers and the responses, I presume, I'm not sure, it was for a period of 2016 to 2017, and it looked at leadership. And I believe this might have been the last one that was conducted, probably when I was still the chairperson. I'm trying to recall, but I think it was. It looked at leadership, communications, employee development, client and community relations, and also significant accomplishments. I noticed that I'm not sure that this is complete. I say that because if you look, it skips from page 6 to page 7. So there looks to be like question 2 is missing, question 4 is missing, and also question 8, 2, 4, 6, 8. So if we can get the full report, and then I'd like to, discuss with the trustees how we want to proceed with the evaluation of the executive director. And I think the executive director has indicated his preference that his compensation and the classification issue not be addressed until the performance evaluation is complete. He feels that that's a more appropriate way to do it, and I think it makes sense that we address the and I'd like to make it have it done much sooner, obviously, than later, and have a set timetable for getting it so that the compensation issue is addressed in a timely manner too. So if I can get the formal all of the different the full performance evaluation report, because the one in here doesn't seem to be complete. And then I will work with the trustees and we'll discuss about how we want to proceed, whether we want to use the same or similar evaluation report, maybe modify it slightly, set a time frame for the employees to weigh in. Obviously, you know, and this looks at all employees, both attorney and staff, professional and non-professional, or non-licensed. And so we'd be able to, I think, get some feedback and then put us in a better position to discuss the evaluation report with sort of this 360 review of the executive director. And any thoughts on that from any of the trustees?
Mr. Chairman, are we going to apply that also to the APD manager?
I was going to bring that up as well. If you look at and we might as well combine these two, that's under agenda item 7B. And we can skip ahead to that and then come back to the executive director. This apparently was the form that was used for the last performance evaluation for the managing attorney for APD. It's a very, you know, I'm not even sure when discussing quantity of work, the amount of work that's performed and completion of schedule, it is a very cursory and not something that I think is appropriate for a managerial type employee for evaluation. But this appears to what's been used before. And I don't know, I guess this is just used for all employees at APD. Is that correct? Anyone can comment on that? Dre, I guess or Annie?
Yes, that is what's used for all the other employees, classified employees.
Yeah, and the last evaluation for the APD managing attorney was used with this form, correct?
That is correct.
All right. Could we also give all of the trustees the actual last a completed one of the last employee evaluation report? That was, and was the only person who did the evaluation was who? Was it just the chairperson who alone did the evaluation?
Yes.
Yeah, and you know, we don't interact on a daily basis with the managing attorney, so I think it'd be difficult, you know, for me to be able to actually, I mean, I don't see her conduct at work or how she gets along with others at work. I mean, our interactions are very limited, or how she meets and handles the public, or you know, her promptness or attendance, etc. So I really think this doesn't provide a very helpful evaluation of. And is there some requirement in our HR manual, rules and regs, that this has to be used?
No, I don't think so. I think they did another survey for her back then when I think the director was done. So we could follow the same route.
All right, if you can find that survey for her as well, I mean, because it'd be good for us to also compare, you know, the prior evaluation or survey and then the current one. Ms. Gail, do you have any thoughts on this, the process?
No, Your Honor. The last two evaluations, my last two performance evaluations was done this way. And I think the thought was they wanted to do something more more along the lines of a complete evaluation, but never got around to it. So it is that's just what happened. But anyway, I agree with Steve that we should probably have a more rounded performance evaluation that takes into consideration a lot more of the things that managers and directors should adhere to.
Thank you.
Your
And
Honor?
that's good to hear. Yes, Ms. Kanata.
Does our evaluation process mirror that of the courts, the Superior Court? I don't know. I was just a question. Does it?
No,
Do they-
not with this form in particular. We have a different performance evaluation that's done, and it looks at different criteria, and there's mid-year performance review, a midterm performance review, and then annual performance review. So it's more regularly scheduled. We'll also look at that. I'll share that as well with the trustees so they can see what was done there, what has been done there. And I'll go back, or if anyone has the history of how we generated, I mean, I believe the 2016-27 timeframe was when I was Chief Justice, and we did that evaluation that did the, overall, and I'll see if I can find any source for that evaluation. But if PD's office or APD's office has, information on that too, if you said Annie underwent that same evaluation back then, but that the last two were more of these sort of very succinct questions 1 through 5 evaluations, then maybe it's time for us to go back. And another thing, I know it's but obviously there's an inconsistency between the APD managing attorney, who is a classified attorney and then was put in a management position and accounted for in that regard, and then the executive director is in an unclassified position and wasn't required to compete for the position. And I'm not sure how exactly about the how that distinction came. It grew out of a period, I think, when I think there was a belief that the attorney pay scale was not adequate to provide for the salaries that were going to be necessary to attract candidates that they wanted to have as executive director. And so I think they felt that going to an unclassified position would provide that flexibility. And so that was why that change was made previously. And we kind of inherited the executive director in that, since has always been that way. I think for Miss Gale, I think there was an appointment to be a supervising attorney from the chairman of the board, then chairman of the board of public defender, and she transitioned from an attorney supervisor to a managing attorney with a pay adjustment from then. And she's always been as a managing attorney, level 5, attorney level 5 managing attorney since that appointment when she was an attorney 4, and then the appointment to went from a supervising attorney or was appointed to be the supervising attorney, and that's when she went to 5. So I think
that's correct, Your Honor.
Yeah. So I think that and she did compete for the attorney 4 position. When obviously it's there. I don't know about the attorney 5, level 5 position, but I think there probably should be some consistency, whatever decision we make with the attorneys, with the managing attorney and the executive director. In my mind, there should be probably some consistency with how we treat them, or if not, justify why there's a distinction between them. Yes, Attorney Telahi.
Thanks, Chief. I was going to recommend that we have our minutes pulled, I think back from, I want to say late quarter 2017. There is a lot of history on the way that this particular evaluation was set up. So I think it would be useful for us to look at some of the history and the way that the positions were evaluated back then. Just simply because when we started talking about this issue, I just had a memory. I thought I could swear we had some difficulty, which is the reason why this particular evaluation was utilized. There was a prior one in place, and I know that both Annie and Steve probably have a lot of recollection of this. So perhaps if we can have some of the minutes pulled from that historical discussion about the reasons why we went there and what the old system was and what wasn't working back then as well, because I think that would help us in look.
Yeah, so, and that's an excellent suggestion. So if we can look for any of the minutes in the 2017 timeframe when this was done, as well as when the performance evaluation, Annie says it was done 2 years ago when they went to the simple form. If there was any discussion of going back to that, other than, just we want to do a more detailed one, but just don't have time and need to do a shorter one. And if that's the response, that's fine too, but we just want to make sure. Thank you. Any further thoughts from Annie or Steve? So I'd like to, get that information out to the board. And then I'd like us to discuss and set by the next meeting, agree upon a form that we will utilize for the performance evaluation with a timetable for accomplishing it. And I'd like to work with the HR at the judiciary and the HR at PDSC, just because I want to, get it done on a timely basis, recognizing that, adjustments in compensation are contingent also on the evaluations, that we get that done as soon as possible. So if, with keeping that in mind, that's hopefully what we'll be able to do.
Yeah, and Chief Justice, so we do have access to SurveyMonkey. So the 2017 one was circulated to the staff by SurveyMonkey. So we could do that again once we come up with the survey questions. And so we'll compile other performance evaluations that have been conducted on prior directors for exemplars. If
yeah, I mean, if you can provide samples of ones that were done on prior executive directors, the minutes from the last times when these performance evaluations were discussed and approved for dissemination, and both for the managing attorney as well as the executive director. And then we will work to try to get that approved and voted on by the board for the format at the next meeting, and hopefully with a return date and then subsequent action by the board based on, and that's just one aspect of it. Obviously, I would expect that you'd have the performance evaluation or the surveys and on some of the key areas, but then you would, armed with that information, I think it's likely that the trustees will sit down with both the executive director and the managing attorney and discuss some of the issues, and then ultimately come up with a final evaluation and decision. All right, is there anything else on that? Okay, if not, then let's, what's the next item on the agenda is the Sixth Amendment recommendations for implementation. And who's going to speak on this?
Chief Justice, I'll be able to speak on this. We did submit our report. It's in the packet, and I just wanted the court to know that David Carroll indicated that he's able to, if he wants to, if the board would like, he could present to the board on his recommendations. I summarized them in my report, And the things that we are working on are like obviously our performance standards. The issue we're having is that, you know, its applicability. Does it apply just to us? Does it apply to APD as well? And can it also be made applicable to the private attorney panel? As well as the juvenile performance standards, those are pretty much completed. And then, you know, we're also going to be working on part of it is that, you know, we're working on developing a program for next year's our defense clinic. We had a really successful defense clinic in October of last year. We're hoping to do something like that again this year, maybe focusing on DNA or some other type of defense related subjects. And then we are still obviously working on our motion bank, trying to figure out how we can make that available to the members of the private attorney panel, as well as other defense attorneys on island. And then we've talked with.
What do you, in terms of figuring out how you have the motions in for various subject areas? You're just trying to find a platform to share it, or?
Yeah, correct. And also so that it's not like why, you know, it'll be accessible mainly to private attorney panel members. So we have to figure out how we can limit access once it.
Well, I mean, I think obviously you could do it with a shared folder very easily, and with login information for people to get into the shared folder with credentials. It's quite simple to do. I'm sure JT or one of them can do it, and you can send an email to the attorneys with the folder and all of the different motions that's available to them. The attorneys who are on the PAP, or other attorneys who may not be on the PAP that do criminal defense that may reach out to you, and you feel it's important to share with them. I don't, you know, I'll leave. It's up to you who you want to share it with, but I don't think that's very difficult. I've shared folders with a lot of information with people, like all the CLE materials, different things, and we do it that way. It's easy to do.
Okay, yeah, so thanks, and I'll talk with our IT guys about the making it easier. It was just kind of an incentive for private attorney panel members to, you know, a lot of them are apprehensive about joining, right? Because they don't have access to motions, so I think we provide them some information, they'll feel a little better. A lot of them have been contacting us, so it'll also make it easier for us to just direct them to our forms bank, and then they won't, you know, be taking up our time as much. And so other things we want to work on is, like, you know, the workload standards. Obviously, the APA just changed.
What
the
about
standards
this liaison with the judiciary? I mean, we do have a criminal case manager now, similar to our civil case manager that we appointed, and I'm sure they'd be able to help you implement tracking of those cases.
Okay, so yeah, we'll reach out to the criminal. Part of the problem is, like, we have stats and APD keeps stats, but we want to make our stats consistent with what the judiciary is reporting out. So, like, for example, we don't really know how many private attorney panel cases there are, and we know how many cases we get off of, and we know how many cases APD gets off, but there seems to be a huge gap between that and what the numbers are being reported by the judiciary in terms of how many court-appointed cases there are. So we just want to make sure we're not missing out reporting on cases. And so, yeah, we reach out to the criminal. Is that she used to be Judge Pinko's clerk, right?
Cindy?
Yeah, Cindy, right? Tiong, is that the
PJ?
Yeah, I like to maybe ask Steve, you know, like the GuamCourts.org has a list of cases where there are decisions that are under advisement, decisions that are issued. You know, we get a lot of complaint. I mean, I get a lot of defendants or their family asking, "What has my lawyer done?" I think it'd be nice if you do what the judiciary has done. Have motions to dismiss, motions to release, motions for EM be placed on your website so that people will be calling up your office all the time. It says, what have you done to release my son? What have you done to this? Is there a motion to suppress? Because my son was justifiably arrested by the police. All those things, but maybe we can alleviate some of the load if you could place any motions you file, especially motions to release or EM monitoring, into your website, so people could your secretaries can say, okay, just look at the website, and it was filed on this date. You could look at it. And so people can just go there and refer to the attorneys all the time.
Okay, access to.
Can you hear me?
Yes, Your Honor.
Sure.
So if we could probably modify your website to include all motions that have been filed in court. And then when the motions are heard by the judge, just take it off the calendar, or just say the motion was heard on such and such a date, or put the motion date on it so that the motion then will be taken out of the website as soon as the motion is heard by the judge. Can we able to do? Can that be done, Steve?
Are you
or,
asking that they post all motions that get filed, PJ?
Yeah, the motions they file.
I mean, that seems like a lot of, I mean, I don't know what the quantity is that we're talking about.
Yeah, but it avoids people calling up their office all the time.
Well, we can tell you our case management system has that feature where, at least events and or documents filed, kind of like a case management system at court, where you can access things that have been filed at court. But I don't know if Abacus has that capability.
But think of it, because you alleviate your attorneys receiving calls all the time from members of the family, especially on how come my son is still in jail? What have you done to have him released? So if you could just refer them to the websites, that would alleviate some of the phone calls that are coming into your office.
Okay, I understand. I mean, especially like a frequently asked question type thing. I think, okay, yeah, we'll work on that, President. Thanks.
People just come to me unsolicited and say, well, talk to your lawyer. I don't know if they file a motion to release your son or daughter or your husband. So at least I can say that, look at the public defender website or the alternate public defender website. If you don't see the motion, then you call them up. But if you see the motion, then you can, that they're doing something. Huh?
Okay. I mean, I think it would be interesting, if we kept stats on like number of motions to release we filed for the year, right? So we should be able to provide stuff like that.
All right, the next item on the recommendation are the workload standards.
CJ, can I have one more concern?
Sure.
I think we should be pressing the magistrates to hear your motions to release a lot sooner, because many times, they wait a long period of time to hear motions. So I don't know, maybe I could talk to the CJ if those motions can be heard 30 days after, within 30 days after replies filed by the Attorney General's office, would the motions be heard? Because many times they just, because of time constraints or whatever, they don't hear the motions as soon as they should.
Oh, yeah, you're beginning to sound like our attorneys, Your Honor. So I remember the old days when we would file it ex parte, right? Once we get all our ducks in a row. But for some reason that practice was discontinued. And so unfortunately, depending on, we often have to nag the clerks to move up a hearing date when we have an electronic monitoring packet ready to go or something. But yeah, we'll have to, I'll try to reach out with Danielle or Cindy Tiong to we need a resolution to this issue just because of the large numbers of people being held, and we do have a lot of clients that are eligible for release, but they're just waiting a hearing date. And so that's something we could, we'll reach out to them about. It's a little frustrating, especially when the magistrate judge tells them within 24 hours, your attorney could file a motion to reconsider your release conditions. I'm like, yeah, we could file it, but it won't get heard for like a month. But that's something we're trying to work on, Your Honor.
Thank you.
Thank you.
That's all, CJ. I'm done.
All right, thank you. All right, and then on workload standards, Steve, I guess you're looking at the new, not so new, but the one done in 2023, the new workload study that was done that suggested the older case law, National Advisory Commission standards that were done back in, I think, in the 70s. You know, what were outdated and not adequate. And so there's some new findings about the average time to represent an individual depending on the type of case involved, as opposed to just a general time frame.
Yeah, so it assumes like a 2,080 hour work year, and based on that, like how many, like how, like it would take, say, they're saying like 15 or 20 hours for a misdemeanor DUI. First degree CSCs might take, 100, like 60 hours. So they've had a panel of experts who basically went over about 20 different case types and said, like, what's the average time you expect to spend? So it's going to have a huge impact, like nationwide, where most public defender offices, which were already, you were using that 150 felony, 300 misdemeanor caseload standard. They're realizing that they're working at 4 or 5 times more than they should. But I mean, obviously, for us to get to that point, we would need to figure out how long it takes to properly and adequately represent an individual in all these different case types. And so that's,
yeah, I mean, but they tell you that, for example, probation or violation cases, 13 and a half hours, misdemeanor, low severity misdemeanor cases, 13 hours, 22 hours if it's a higher misdemeanor, DUI at 33 and 19. So it gives you the hours that are expected, and this is just average, and obviously we have to use some criteria, and that gives us the average based on that. So when we get a breakdown between each attorney on the type of cases, and then that will tell you the average number of hours it should take the attorney to complete the case, and then figure out the the work hours based on the 40 hours a work week or whatever, and the number of hours that would be required.
yeah, so we haven't tried, I mean, we know we keep detailed enough case type stats to generate our own if we assume that those hours are correct. We just haven't, that's something that
we're not going to be able to, I don't think, at least at this, do our own workload study.
That's correct.
And so at least at a beginning, I think we should just utilize the average that they indicated, and if there's some reason we need to depart on it or gross it up or gross it down, we can always consider that. But I think at least as a starting point, let's look at their average that's done by this expert panel, and utilize that with the case types that we have and the attorneys that we have, and then determine, give us a better, at least it's a start. And we could say, well, it's not entirely realistic because X or Y, but it at least can give us a baseline from which we can have a discussion.
Oh, definitely. And what's interesting is like the caseload caps that for the private attorney panel, they almost all fall within the recommended hours or maximum average hours for those types of felonies. So I think, we're really not that far off the private attorney panel side, but it's just our office that So we'll try to calculate that and put the report together using the new.
All right, if you can, yeah, let's try to get that done. And then the next is something about abacus to conduct the workload study. But I think, yeah, you can do that, but that's going to take more time. And I think you need it over a period of time. And if you haven't started that now, for the time being, I think we do the workload study with the stats that they've done. And then if we're able to get supporting data to modify it in the future, we can look at that. And then the next recommendation is about the structural justice issues. And Steve, you and I have had a discussion about this. I don't think there's such a thing as being, part pregnant, peer pregnant. And I think that, if we are going to create a commission to handle indigent defense, and that we should go forward with that. And I think at the beginning, at least for our discussion purposes, let's ask the Sixth Amendment Center to send us proposed legislation that creates it. I don't think that having a changed composition of the board alone or is really, I think, the solution that they were looking for, the report that was looking for. And you've been, I think the speaker raised that based on at least her discussions of the report. I think there was some public hearing, or so maybe it was in the comment in the context of the budget. And she said she has had discussions with you in the past about the structure. And I think that, if we're going to head down this path, and I think that there's a push to do so. Clearly, the recommendation is that from the Sixth Amendment Center is to do that. Then we should go forward and indeed have. And I'd like to see what legislation, if they're willing to continue to provide, some of the technical assistance. Send us a proposed bill for us to look at and discuss, and then get behind that creates the commission.
So we'll reach out to Mr. Carroll about that.
Yeah, but I can tell you, I'm not really keen on doing a piecemeal approach. I think if we're going to make the move, we be bold and we make the move and we get it done. And I don't think that a piecemeal approach with, still having a board of trustees, maybe with different composition, not addressing how the private attorney panel is going to be governed by the commission, not govern, all the other issues that were raised. I think I'm not keen on doing that. I'd rather just, get it done. If that's the recommendation, and they feel that that's the best way to proceed, let's go for it. There might be some growing pains at the beginning, but the legislature needs to understand what will be entailed, the funding that's going to be required to accomplish it, and whether that's going to solve all of the indigent issues remains to be seen. I do know, I'm not sure about states that have maybe implemented in its entirety recommendations that have come from the Sixth Amendment Commission. I'm not sure if there are any that have implemented the recommendations in total, but I do know that many jurisdictions are facing issues regarding indigent defense. I was just talking with another Chief Justice from another jurisdiction, and the comment was indigent defense is having some serious issues. They said is burning up, was what he said, in many different jurisdictions. But if we feel that the creation of the commission will help address some of those, then I think we should do that. And let's ask them for their proposed legislation.
Okay. Yeah, and Chief Justice, I mean, the judiciary really for the last 50 years has been protecting the right to counsel for Guam, but really it is the constitutional right that all three branches should strive to protect, and hopefully the commission could, if they, however it's constituted, could ensure that. And so we'll reach out to Mr. Caro and get something going. I mean, we're fortunate because Guam is like the perfect model. I mean, we're the perfect model to implement any type of model legislation, right? Because we're small enough to adapt, and all the shareholders are, obviously interested. So we'll get something together. We sent Sarah a bunch of different models from different states, but we'll reach out to them and see if they'll have proposed legislation specific to Guam.
Yeah, I mean, I think we should at least get that for discussion amongst the trustees, to get behind it. Obviously, the judiciary has to, come to grips with it as well and make their recommendations and edits, but the trustees have to have that discussion and push for whichever direction that they want us to go forward, and if we're going to adopt the proposals that are there. All right. The next item, another recommendation, is the citations and notices to appear.
So that one, I know that the report kind of suggested that people are going 3 years without an attorney appointed to represent them. And really, that's only in the case where a notice to appear is issued. And instead of charging them timely, the AGs wait till right before the statute of limitations expires and then charges them. At which point, good luck trying to find evidence from something that happened 3 years before. So we just have to figure out a way we can get the Guam Police Department to inform individuals when they're given a notice to appear that they should come to our office or APD if they financially qualify and get on our list of clients. We do have people coming in every now and then with citations and notices to appear. We could advise them before they're even charged. So that's something that we need to work on with either GPD or the Department of Corrections in terms of providing individuals arrested and given a notice to appear to come seek our assistance.
Well, of course, they're putting in to avoid any issues that happen, based on the Palomo decision, the last outside date that they can. But, there can also be a statutory solution to that, right? And I think that was recommended that by the Supreme Court when they published the Palomo opinion, or some of the cases that came subsequent to Palomo, about looking for so that the citations and notices of appear don't necessarily have to have a date that is 2 or 3 years down the road.
Yeah, I mean,
because before the Palomo decision, that was never the case. Right, those citations and notices to appear were usually 30 to 60 days, if not sooner. They had a notice of appearance, or first their initial appearance. But it was based on the Palomo decision, and it's been a while since I've looked at it, but it was based on this statutory interpretation.
And maybe that the Criminal Law Revision Commission is going to address that.
Or, and they can look at that, and that's something that can be brought to their attention. All right, and then the financial eligibility, obviously we passed new guidelines, but what additional provisions?
So, there are other additional provisions, like some jurisdictions don't count income of spouses, especially when they're estranged, or they don't, if they look at net income, not gross income. So if they have a mortgage that's paying off a house, if they cannot sell the house, within a quick enough time to if they can't get liquid fast enough, then they don't. Some jurisdictions don't include stuff like that. So, it's just a list of, and we'll develop the list, and we could have the board decide which ones.
Yeah, I mean, I think what you should do is give us a recommendation with proposed language to the guidelines. Okay. And then I think we're in a better position to evaluate it and discuss it and vote on it.
Okay, and so that's something we're working on It's
Okay. And
already
then the
addressed.
third conflict panel, I mean, we've had a number of discussions about this.
Yeah, and in a way, it already exists because the Civil Law Center, they're taking appointments for PINS cases. But that's something that I think is gonna tie in with if we eventually have an independent commission, that would also, that'll be a problem that they'll be able to resolve.
All right.
It's
Okay.
something that's part of that discussion.
So at least for now, let's look at the legislation and the workload standards. Those seem to be things that we can work on, the legislation for establishment of the commission and on the workload standards that we can do. And then someone can be looking as well at or at least making a recommendation and evaluating on the citations and notices to appear. And then, of course, the guidelines will take more. But in terms of, items that we think we can get on right away, clearly the workload standards we should be able to do, and the proposed statutory language and the motions bank, the liaison with the judiciary, with the criminal case manager. I think we can do that. All right. And you said you already completed the adult and juvenile performance standards. And if you want to circulate that to the board, that's something we can also start looking at if you're waiting for approval for that.
Yeah, well, we just have to put the adult one in final form. I think the juvenile one's in final form, right? And we could roll that out, and then we'll figure out who it applies to. I mean, I don't know about the private attorney panel. I know at one point they weren't really keen on the idea of juvenile performance standards, so
we'll keep these on the agenda, the projects under the Sixth Amendment, so we can get updated and see what this progress is made on these various projects and do that. So the Sixth Amendment report and the implementation of it will be kept on here so we can go through and continue to see how we make progress on that.
okay, great.
All right. Is there any public discussion for the meeting? If not, our next meeting is going to be on July 23rd at 12:30. And can I entertain a motion to adjourn?
So moved, Mr. Chairman.
All right, moved by presiding
Seconded.
judge, seconded by trustee Kanata. There being no objection, the meeting will now stand adjourned. Thank you, everyone.
Thank you. And
Thank you.
Bye.
I'm confused. Do you look at that or do you look at the screen?